Good morning. Okay, we have, well, I guess a total of a bunch of cases for argument, but we're going to, some are consolidated. So the first case that we have scheduled is C-250516, and this is Begley versus Begley. Are the attorneys here?
Fred Miller for Mr. Begley,
And we'll also hear from Mr. Bailey, Your Honor.
Okay.
Michelle Steiner for Appley Ready to proceed.
All right, good morning. The next case, we have C-250410 and 411. That's Freeze versus Greg G. Wright and Sons. The attorneys in the room?
Good morning, Your Honor. Kevin Fizdale for the Appley Carl Freeze.
Good morning.
Tom Grossman on behalf of the defendants, myself, and Reggie Wright and Sons. The only defendants I'm not representing are CKF and Charles.
Okay,
And Your Honor, David Partridge on behalf of CKF.
okay, all right, great. So we have everybody here. And then we'll talk about splitting the argument when you guys,
It was explained that we've only got 15 minutes.
right. But we'll talk about that when you get up here. All right. And then the final cases that we have consolidated for argument, C-250189, 190, and 617, Gautier versus Gautier.
Good day, Your Honor. Robert Fisher on behalf of Sue Gautier.
Bob Klingler, Your Honor, on behalf of the appellate.
Okay, great. Thank you so much.
I'm Tom Grossman, I'm on behalf of Forsyth.
Yes,
This is my day.
this is your day, all day with Mr. Grossman. All right. So we're going to start with the Begley versus Begley case. Would you like to reserve some rebuttal time?
Yes, Your Honor, I would like to reserve 3 minutes if I may.
You may, and whenever you are ready.
My name is Fred Miller. I'm here on behalf of the appellant, Dan Begley, and I know this court is aware of what the issue is the homeschool issue, because father does not believe, and we believe the evidence was clear, that homeschool was probably not a good option for the girls at this time. And of course, the precise issue is whether the court should have relied on the expert that was provided by mother, Vivian Chen. She really was not an expert, as I see it. She was a friend of mom. She had been at mom's karate school since she was 6 years old. And I don't know how old she is now. My guess from reading the resume is late 20s. She has had an ongoing relationship with mom for at least 20 years as an instructor in her school, as a student in her school, and so it seems like she was doing a favor to mom to just provide input as to what would be the better school or better option for the girls in this case.
And you're saying the court relied upon her testimony in rendering its decision?
Absolutely.
Okay, and specifically, what did the court say about that? As far
Well, the
as-
court found her to be more credible. There were two experts provided by mother, and we're not talking about the other expert. But she said that these experts were more credible than the expert provided by father, because the father's expert had probably made a mistake based on what the girls had told her about their socialization. And then the trial court, when it overruled the objections, specifically stated that they were credible and should have been relied upon.
And Chen, what was Chen's testimony used for?
It was used to determine that PEP was a better option than CCA. She had reviewed an outdated website of CCA to determine that CCA did not provide sufficient rigorous education for the girls, and she relied on a PEP website and to decide that PEP was a better option for the girls. The problem was Mrs. Chen had said that the girls need AP, especially A, and I'm just going to refer to the initial, A needed AP classes because she's gifted, and there was no argument about that. she's gifted, her sister is average to above average. She's gifted and needs specialized courses such as AP, and there's no doubt about that. And Mrs. Chen said, well, she needs like 10 AP classes to be able to get into college, to get into a select college. But PEP doesn't offer AP classes. They don't offer CCP classes, College Credit Plus, which is affiliation with a college. CCA does have those things. But Vivian Chen seemed to ignore that. She probably ignored it because it wasn't on the website, and all she did was look at the website. She didn't talk to anybody at CCA. She didn't even talk to anybody at PEP. There were
Counsel, I know this is your second assignment of error, but the trial court ordered the school decision to be revisited in 2 years, which, from my understanding of the age of the children, would be before the oldest child's 11th grade year.
Yeah.
Would that revisiting address some of the concerns that you're raising about curriculum entering into the 11th and 12th
No,
grade years?
because we still have 2 years to go before we get there. Certainly, it's nice that they were going to review it, and of course, I'm arguing they should review it sooner than that, because 2 years is a long time to wait.
Well, is it would anything in the record support the idea that the oldest child is going to be taking AP classes in 9th grade?
Well, not if she goes to PEP, because they don't offer AP classes, and Mother is not qualified to teach AP classes. And that means she's going to have to go elsewhere to a different co-op or have a different tutor to get these AP classes. Now, the girls, this is going to be the third co-op that the girls have been in since COVID, and third co-op in 5 years. Talk about stability. Now they're going to have to go to a potentially different co-op to get these AP classes that Vivian Chen believes are necessary. And we have no reason to doubt that. She does need the AP classes, but they're just not offered at PEP. PEP doesn't have accredited teachers. They have people, volunteers, who are so-called sub-experts in their subject matter, and that may be, but that doesn't make them a teacher. You can know something, but you don't have the ability to convey that information, especially to a high school class. The parents vote every year as to which classes are going to be offered for the following year. So there's not even any guarantee that the AP classes that A needs, and she's an engineering student, are even going to be around when she needs them. The PEP doesn't offer any sports or extracurricular activities, but CCA does have all these things. CCA has certified teachers. They have a wide network of homeschooled children who have left homeschool and have gone to CCA. They have an affiliation with Hillsdale College. Vivian Chen had said, well, there's no CCP, which you need an affiliation with the college. There's no CCP, College Credit Plus, at CCA, but there was. But the problem was, again, with Vivian Chen, she didn't bother to talk to anybody. She just looked at the website.
Counsel, what I hear you to be arguing is that the trial court perhaps went against the manifest weight of the evidence, but that's not an assignment of error that you've raised in your brief. Your assignments of error focus on whether Chen was qualified as an expert and then whether the 2-year schedule for revisiting the decision was appropriate.
That's correct, because I know abuse of discretion is a hard standard to overcome, and if you just argue that, well, the judge had, or the magistrate had different options, abuse of discretion is going to be difficult to overcome. But if you look at how she arrived at that, how she used that discretion by relying on testimony that really was discredited, then it becomes a different ballgame. If you take Chen out of the equation, and I know the appellee mom argued that it's harmless error because it would have been the same anyway, but not really. You look at what the Guardian had to say, and the Guardian's report, which is a lot more thorough, a lot more detailed than what Chen had to say. And the Guardian was aware that engineering's not available at PEP. The Guardian was aware that AP is not available at PEP, that CCP is not available at PEP. And the court didn't totally accept what the guardian had to say. I recognize that. But the court did accept what Chen had to say. And if you take Chen out of the equation, that leaves us really with what the guardian's recommendation was.
Well, wasn't there another expert, that testing expert that
Yeah,
conducted
but-
some tests on the girls?
Right, the testing was that A is gifted and that N is average to above average, and nobody's disputing that. That expert didn't weigh in on what school or what program the girls should go to. So we have no beef with what that expert had to say. See, I'm almost out of time, I see.
You had 3.5 minutes.
Well, I want to save some time for
No,
rebuttal.
I've already saved your rebuttal.
Okay. Oh,
I
that's,
started you at 12.
oh, okay, so I have 3 minutes left in the original.
After this.
Oh, okay, thank you. There are new classes added every year at CCA, and there's also engineering classes available, 4A. So it just seems to me that the court was wrong in relying on what Chen had to say. On top of that, Chen being the friend of Mom.
Was that an objection below to the magistrate's decision? The potential bias because of
Yes,
the relationship?
That was one of the objections about the expertise of Chen, and that she really was not an expert at all.
Well, I understand that part. I'm asking if there was a specific objection to Ms. Chen possibly having bias towards mother
that
because
was-
of their relationship.
Yeah, that, I would have to check again because I don't have it in front of me, but I'm absolutely sure
Okay.
that was part of the objections.
Thank you.
Now, the judge didn't really rule on that part of the objections, but I know the standard is that if you don't mention it, then it's presumed to be overruled. On top of this is you have a very close-knit relationship between Mom and the two girls. And of course, there's nothing wrong with having a good relationship with your mother. That's what we all want. But this seems to be overboard. Mom is with them all day, every day, for class, for Taekwondo. She's one of the volunteer teachers at the previous co-op learning tree.
Counsel, how does that, even if we agree with you, how does that factor into your two assignments of error, which is that admitting Chen as an expert was an abuse of discretion, and then the 2-year
It factors
revisitation
in
schedule?
with the harmless error argument that the other side has proposed, that it's not as black and white as they would have this court believe. There are nuances, and that's one of the nuances, that if you throw out Chen's report, then you've got an issue of what the guardian had to say, and you've got an issue of why this is important to follow what the guardian's recommendation is, which is because of the need for the independence for these girls. They're very insular, as I read the record. They depend on each other, and they answer for each other, and they're going to be lost without each other. It's going to end in a few years anyway, when A goes off to college and N will be in high school at that point. There's nothing wrong with kids going to separate schools, which Mom seemed to have a problem with. There's nothing wrong with kids being separated for a period of time, which Mom seemed to have a problem with. Mom said, well, if they go to CCA, then I'm never going to see them because only on weekends and in the evenings. Well, that's pretty much every family. So this need for the independence, I think, is something that the trial court, the magistrate and the court did not take into account. And that goes into the area of harmless error that the other side has brought up. And now I see I'm out of time.
You're at your initial time. You still have your rebuttal time.
Good morning.
Morning.
May it please the court and opposing counsel. I represent the mother in this matter, Jamie Hamilton. We did file a responsive brief to the two assignments of error that were raised. I would like to discuss the Vivian Chen. Was she an expert? Was the trial court correct in finding her or deeming her as an expert. As the court pointed out, this is an abuse of discretion standard. And I did not see anything either in the transcript or the arguments of opposing counsel that would rise to the level to show that this court abused its discretion in finding that Ms. Chen was an expert in her field. And to be clear, this individual was brought in because she has training as a college admissions counselor. She had years in this field. She had helped several students get into very prestigious schools. And so Mom, when we talk about hiring her, she went to her to get some guidance on what classes Mom should pick for this homeschooling program that she's involved the children in. So it wasn't starting out as an expert, but it was somebody that she was comfortable with and that she was aware of what she did and how
They were
successful she's
friends?
been. They were, I guess you could call them friends. I don't know that they did much socially, but yes, they were involved in the Taekwondo, right. But it's because of that relationship, she was aware of the expertise that this person had and wanted to get some guidance. And I will tell you.
Those facts were known to the trial court. That all came out below, that they had this pre-existing relationship.
That's correct. And that was explored a little bit by Father's counsel, but not to the extent that he wants to argue that there should have been bias. He brought it up as an argument, but then didn't really go into the details of it, where the court would be like, okay, I think she was biased in her testimony. I think the magistrate heard and the judge reviewed that there was some testimony about that in the relationship, but did not find that there was bias.
Well, it sounds like some of the facts that Chen testified to could arguably be against Mother's position in this case, because Chen testified that a certain number of AP classes were necessary to be accepted into prestigious colleges, and what I'm hearing from Dad's position is that that range of classes may not be available in the homeschool program, and that enables Dad to actually argue against Mom's position, right?
That is true. But I will say in response to that, Ms. Chen also testified that it's not so much the label of the AP class, but it is the substance of the class. And that was one of the reasons why she did the report she did, so that she could give Mother that guidance on what should be offered to her. I also say that Rachel Sargent testified regarding the PEP program, and what she said is that program is an accelerated program, and whenever you look at the transcript, it'll show that each class taken at PEP would be an honors type class. So it does have that content of the AP, but I guess Ms. Chen also said that the point is, if you have the material, you study it, you know it, and you can take the test, you don't have to be in an AP class to get that designation. And these children, they have been homeschooled for pretty much their entire lives, and by Mother, who is not a teacher. I mean, she is an intelligent woman, she's a hardworking woman, but she is not a teacher in the sense, and I know that Mr. Miller talked about that. What she's done with these children, they are not just doing well, they are doing extremely well. The testing that was done by Mark Powers showed that the older daughter was testing into high school and even college classes, and she was in 7th grade. This is all through a homeschooling program. Clearly, Mom knows what she's doing. She works very hard. She does the research, and all that was testified to. The younger daughter, same. She's not quite as gifted as the older child, but is still doing way above average in the classes. So Mom is doing what she needs to do. And Mr. Powers also testified it was his opinion that this homeschooling program is what was best for these children, that they were going to continue to do just as well if they stayed in the homeschool program versus going to the brick and mortar school. This whole idea of brick and mortar school was from Father. He is very out of touch, and that you could see that from the testimony, with the needs of his own children. He didn't even understand what they were involved in, how outgoing and social they were. He testified the youngest was very withdrawn, which everybody else who testified said that's not true. They are doing so incredibly well, but he decided, well, I think they need to go to a regular school, and so I'm going to file a trial.
Counsel, am I recalling the record correctly that the girls themselves indicated they wanted to remain in homeschool?
Yes, and that's another piece of this. As Mr. Miller pointed out, and we did in our brief, even if we did not find Ms. Chen to be an expert per se in this, if that was set aside, we've got all this other testimony from Ms. Sargent, from Mr. Powers, from my client, that these children were doing exceptionally well, And that was the children's wishes, which is part of the court's consideration when they're making these decisions. And because of that, for all of those reasons, we believe that even if Ms. Chen is found not to be an expert by this court, it would be harmless error. That there was overwhelming evidence that this homeschool program that Mother has put together with the assistance of Ms. Chen is what these children need, maybe not every child. Because I didn't do the litigation case, my partners did, but what I found amazing, I guess, is that the magistrate initially had not a bias, but I'm not sure homeschool is a great program. I mean, she was pretty candid about that on the record. But then, after she heard all the testimony and saw how well the children were doing, she said, I think this is what's best for these children. And we believe that the evidence show that. The second assignment of error that kind of goes along with this about whether it should be revisited, one of the reasons, and I think the crucial piece of this, is that to give these children some peace. Let them do their schooling. Let them not have to worry about their parents arguing in court, which they've been doing for the last 3 or 4 years. Let's give them some peace. Let's give them some stability, because this is what they really want. And the magistrate also said, just because I'm saying you've got to wait 2 years to have the conversation doesn't mean you have to. The parents were meeting regularly, I think monthly, to talk about the kids' progress and schooling, what they need. That can continue to happen. They can talk as much as they want. They can come up with an agreement whenever they want. The court just said, we're not going to address this for 2 years, again, to give some stability for these kids.
And that would be before the older child's 11th grade year?
That's correct.
And some of these curricular concerns could be revisited at that point?
Absolutely. And again, they can be revisited anytime. Court has ongoing jurisdiction. The court just wants the litigation to stop so these kids can do what they're supposed to do and be kids, to do school, to do their activities, and to enjoy their lives. They get one childhood, and they don't want to have to worry about their parents litigating for their entire childhood, which is where they're at right now. And that was why the court made the decision it did. And again, I don't believe that it's been shown that there was an abuse of discretion for that time period to be 2 years. And so we believe that the decision of the trial court should be upheld. Thank you.
All right, thank you.
May it please the court, these parties went 9 years from their divorce dissolution till mom filed the first motion. So they can have peace. And then mom filed the motion and got the ball rolling with bringing in the litigation. And I heard a lot of talk about how you need to give the children peace and the constant litigation is hard for them. And that's not in dispute, that children don't need to be part of that. But for the parents to meet and talk about what was going to happen, the kids don't even have to know that the parents are meeting and talking about that. They were meeting monthly, and then the judge or the magistrate changed that to every 3 months. So they're going to be meeting anyway. That doesn't mean there's litigation. That doesn't mean there's arguing.
Well, I mean, the order doesn't prevent them from talking about it and possibly, changing minds or, coming to a different decision together.
Well-
It just simply says that, in 2 years, it can be revisited, but no litigation in 2 years? Am I understanding that
No,
correctly?
Clearly they can talk, but they're talking every 3 months about the children's progress.
Sure.
And about their homework and what they're doing, not about where they're going to school. And that's
But they
the issue.
could if they wanted to.
Well, they could, but mom doesn't have to.
Right.
And mom has no incentive to if she's getting exactly what she believes is the right course of action. And if dad brings it up, she'll say, well, 2 years aren't up, I'm not going to talk about it. And I'm not suggesting they talk at every 3 months about where they go to school, but you would think once a year would be a valid time to talk about it. How are the kids done this year, and where should they go next year? I don't see anything wrong with that, and you don't have to tell the children that this is what we're going to talk about. They're not being drawn into any litigation because the parents meet. They're meeting anyway.
You're making a case for why it would be reasonable to talk in 1 year, but why is it unreasonable to talk in 2 years?
Because the time has gone by. Then the older child, you only have one year left, going into 11th grade, maybe 12th grade. You only have the last year. And then to change schools at the last year, that's probably not very practical either, to go for the 1 year or maybe 2 years. You would think that if she was going to have the high school experience, she would have the whole high school experience, not just a small part of it. And so I just think that the 2 years is just unreasonable under these circumstances and with the facts that we have, that the children, of course, are getting older and changing grades every year. I heard Ms. Dagnero say that Chen has a lot of training to be a college admission counselor. By her own admission, she has 0 training. She has experience, and this is what she's done, 10 cases in 5 years, something like that. She sort of seems like a hobby or a sideline to her, based on her resume. If you look at her resume, and it's in the record, she's all these financial, and she's a sommelier, and she does all these other things. And listed in her qualifications is nothing about being a college admissions counselor. And I see I'm out of time again.
You are at your time. Thank you.
Okay, thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay. All right, the next case is Freeze versus Greg G. Wright and Sons. So we have Mr. Grossman for Greg G. Wright and Sons, and then Mr.
David
Partridge for CKF. You will be splitting time, and the way I'm going to do this is just let me know how much rebuttal time you'd like, and I'll let the two of you figure out between the two how you're going to split your time. I'm not going to tell you anything.
Objective decided that already. So I will take 9 minutes, you will take 6.
Mhm.
I will have 6 minutes to make an argument to you, and we'll reserve 3 minutes for rebuttal.
All right, so I'll reserve your 3 minutes, and then I'll let you guys keep your initial time between, just,
Could you tell me when my time is up, my 6 minutes?
I'll try.
Okay.
You're starting with 12, so when you hit 6,
I'm getting 9 minutes. 6 minutes and 3, isn't that how it works? I only-
well, you want 3 minutes for rebuttal.
Yes.
Okay, so you're gonna have 12 minutes to split between the two of you for your initial.
Your Honor, would I get a rebuttal as well?
You can split your rebuttal time as well, however you guys wanna do it. So split your, well, this is the easiest for me to keep track of. So you can split the first 12 minutes, and I'll reserve your 3 for rebuttal.
10 and 5, could we do that? 10 and 5?
Okay.
Okay, thank you.
Mm-hmm.
And all, Your Honor, will come up in 6 minutes.
Okay, sounds good.
So much. So may it please the court, my name is Tom Grossman, and this case is actually decided by an exhibit that we gave to the arbitrator, Exhibit 69 in the arbitration, and that's this court's opinion. This court decided what was arbitrable and what was not. It decided it was specificity. It explained its decision. This is the law of the case. We told the arbitrator about this. The arbitrator knew about this. Apparently, the arbitrator never read this because it's not in her time charges. But she gave us an itemized account of this. We repeatedly referenced it. The other side dutifully followed this opinion. They only filed for arbitration of conversion, unjust enrichment, and breach of fiduciary duty. Then at the very end, when they sought an award from the arbitrator, they went into an entirely about their indemnity and reimbursement claim, which was not arbitrable, and the civil conspiracy claim, which was not arbitrable. That's what happened in this case. We objected repeatedly to this. This was not subject to arbitration, so you may vacate when an arbitrator does not follow the jurisdiction of the grant of this court. This court determined it. It's entirely controlled by this opinion. There's nothing justified in what they did. Now, I filed a brief, and I'm sorry, I'm a little bit nervous as more than normal because I'm a defendant. I owe hundreds of thousands of dollars for this company to banks still. They want to destroy this company.
They want to take all of the assets of this company. I'm still going to owe all this money to these banks. I never received a dime from this company. When I was a member, I was not a member. Well, first, I was a manager originally. My mother gave me 25% in 2005. When this matter came down, and we got sued in the first case before Judge Martin on this equipment lease defaults, where Mr. Freeze was the guarantor. Not my family, not me, not my dad, not my mom. My dad was never a member. He was a manager, but we were both so disturbed, my father and I, by what had happened. And the arbitrator agreed that Mr. Freeze didn't tell us anything about these defaults on these equipment leases. We brought in a specialist named Dennis Allen to look at the company. Within a week after he left,
Wasn't that claim dealt with in the arbitration?
What's
The claim that Freeze breached the fiduciary duty. Wasn't that a claim that you raised in the arbitration? And wasn't it arbitrated?
I did not raise the issue of indemnity. I did claim that he breached fiduciary obligations for a lot of things, including not telling us about it, but not that we weren't not litigating the issue of whether he had an indemnity right or a reimbursement right. No, that's not what I raised at all.
No, that's what he raised.
No, he didn't raise that. He only raised fiduciary obligation breach, and only the conversion breach and the unjust enrichment. He didn't raise the right of reimbursement until the very end. And it was in the briefing at the very end that he raised it. And we objected immediately in the briefing before the arbitrator. We objected. We said, no, you can't do that. You can't award attorney's fees. You can't do any of that thing. And he didn't present attorney's fees as damages. That wasn't
He
in.
raised 4 counterclaims, right? In the arbitration.
Yeah. He did. He raised his
And one was breach of the indemnification clause of the operating.
No, that was not raised.
That was not one of his 4 counterclaims?
No, it was not. In fact, I got his paperwork right here with me, right now. He only raised the statement of claims right here.
He only raised what?
Well, I'll tell you what he raised. He only raised the conversion, unjust enrichment, and breach of fiduciary duty. Number 1, breach of fiduciary duty. Count 2, unjust enrichment. Count 3, conversion. That's it. I complied with your order. I didn't raise those things. I didn't do that.
So when did the breach of the indemnification clause come into play?
It didn't come into play until the arbitration was over, in his briefing at the very end. And we objected. We told the arbitrator, no, you can't do that. That's contrary to the First District Court of Appeals decision. This one, which the arbitrator never read.
Well, isn't there a difference in the indemnification claim that was raised in the complaint that was filed, or the counterclaim the complaint that was filed in court, and the claim that was filed in the arbitration?
It was identical. This claim is identical to the pleading before the court.
I don't think that's responsive to my question.
Oh, I'm sorry. I didn't
So
understand your question.
the arbitration claim has as its source of indemnification the clause in the operating agreement. It derives its identity from the operating agreement.
No, it does not. That is not what the Court of Appeals said in your
I'm not talking
prior
about the Court of
decision.
Appeals, I'm talking about the arbitration.
Yes.
What the arbitrator determined is that there was a right of indemnification under the operating agreement.
She's wrong. That is, if you read, this is addressed in this Court of Appeals decision.
I'm asking about the identity of the claim, though.
She
You
was
may
wrong about
disagree with
that.
how she interpreted
Yes, she
the
was wrong.
operating agreement.
And she's not
But
only
the
wrong.
source of the claim that Freeze was making is that the operating agreement entitled him to indemnification.
No, it did not. And here's what the Court of Appeals said, and this is the argument we made post-hearing on this. We said that the claim for indemnity arises under Ohio law. It does not rise under the operating agreement. It can be pursued by him regardless of the operating agreement. That's why.
I'm looking at the damages awarded section of the arbitration
I know, that's what she
decision
said.
right now, and she says, respondent's claim for breach of the indemnification clause of the operating agreement is granted.
I know, and she did not follow this agreement on arbitrability. I know that she did that. That's wrong, because there was no jurisdiction for her to do that. That's what our point is.
But
And
the
that-
operating agreement does have an indemnification provision, right?
Yes, and this is covered by your opinion, your prior court's opinion. Because what the court said is, yes, there's an indemnity provision in the operating agreement. It provides that you have indemnity pursuant to Ohio law. And the court said, because it's pursuant to Ohio law, not pursuant to the operating agreement, it is independent of the operating agreement. And because it can be pursued without reference to the operating agreement, it's not arbitrable. That's your decision in this case.
This
It
is a
all
separate
business.
claim, though. He's pursuing this claim based on the language in the operating agreement.
He cannot do
He may
that.
have another claim that is separate from the operating agreement.
Cannot do that, and that's decided by you. This is entirely decided by you in this case. This opinion deals with that precise argument. That precise point is dealt with in this Court of Appeals decision.
Mr. Grossman just wants you to watch your time for
Okay,
your
am I up
colleague.
to my 6 minutes now?
You have 4.5 minutes
Well, I
left
think
of the initial.
CKF needs to argue now.
Okay.
Thank you.
Your Honors, may it please the court. I represent CKF, and I would just like to clarify.
What did CKF file, if anything, below to preserve its ability to appeal?
It did not file a motion to vacate. However,
So how does CKF have standing to appeal in this case?
Yes. The federal courts under the FAA say that where a party does not move to vacate an arbitrator's award, all defenses except for arbitrability are time barred or waived.
We're not in federal court, and nothing was filed below, so how does CKF have any ability to pursue an appeal here? They didn't file anything below.
Well, it is persuasive authority, the Federal Arbitration Act case law. And so there's nothing in Ohio law, as far as I'm concerned, that says you cannot proceed with a appeal of a arbitrator's award if you were a non-signatory and your rights were impacted.
And so you're arguing that even though CKF was not a party to the arbitration, and it did not challenge the confirmation of the arbitration below, it can still appeal here?
Correct, because it goes so to the root of jurisdiction and arbitrability that it is never time barred, essentially.
Did CKF move to intervene at any point?
No, there's no notice given to CKF about any of that it would be ruled on so extensively in the arbitrator's award, despite being told by this court that all of the core set of operating facts involving CKF, which expands to Mr. Freese's personal guarantees on the PNC leases. And that's, I think, a key distinction.
Help me understand how CKF's rights are affected at all, because there are the pending claims still to be disposed of in front of the trial court, and I do not believe that the arbitrator's award has any res judicata impact on those claims, given that CKF was not a party. So aren't you going to be starting on a clean slate when those cases come, or when those claims come before the trial court?
I think that, to answer your question, that is unclear, because there is already another appeal that is going to be coming in before this court, which it seems like we are being prejudiced already, because we filed a priority determination and there wasn't a priority determination. But the standing rule, I believe, does require, it's fairly permissive. It has a present interest in the subject matter of the litigation. So this court said CKF had no relation to the operating agreement, and the award said that Greg G. Wright, by creating CKF, violated the operating agreement. So the core set of operating facts, this is the key, I think.
The arbitrator may have found those facts, but those facts are not going to carry forward to the court's determination of the pending claims.
Yes, the trial court's confirmation cannot validate an alter ego finding, but that doesn't remove CKF's ability to challenge the fact that there was an alter ego finding by the arbitrator.
How is CKF at all impacted by that finding? They don't owe any money, nothing is changing about CKF with respect to the arbitrator's award.
Your Honor, it clouds CKF's corporate separateness.
In what
It
way?
clouds
How is
CKF's
CKF
judgment.
injured?
Because when there's an alter ego finding that's confirmed by a trial court, then it can imply that the defenses that would apply to Greg G. Wright, the alter ego that the arbitrator alleges, would also apply to CKF. And that would mean that CKF could not proceed to collect on its own separate, completely separate judgment in a completely separate case against Mr. Freeze.
So it's your position then, I just want to be clear, it's
Yes.
your position that those claims that are pending against CKF are not on a clean slate, and that the arbitrator's award does impact and will change the outcome of those claims? You don't get to litigate those claims anymore.
I believe that the way that, I am over time, but just to answer your question, I do believe that the way that this was handled by the arbitrator and the award, where it ruled that there was a civil conspiracy, it ruled that there was fraudulent concealment of CKF's purpose, it ruled that all of the PNC personal lease guarantees were indemnifiable and subject to indemnification, even though this court said you cannot rule on the personal guarantees at all. They're outside of the core set of operating facts. The fact that the award went and got that whole set of core operating facts, it started with the one which is unrelated to CKF, that's true. It started with the one that, the personal guarantees, but then it led piece by piece finding CKF was Greg G. Wright. Greg G. Wright.
I guess let me ask this question differently. Do you believe that the court, in determining whether it's through summary judgment, a trial, whatever mechanism, do you believe that the court could reach an opposite factual determination with regard to the pending claims against CKF?
That is completely, I do not know that. We filed a motion for summary judgment before the trial court after arbitration. We tried to remove summary judgment for one of the 3 non-arbitrable claims, and the court would not let us file that. She just wanted to handle the arbitration completely. So I don't know what that implies for how she views whether all the claims have already been decided, but I do know that by the language of the arbitration award, CKF is implicated in all of our claims, and even the whole core set of operating facts involving the PNC CKF leases, that's all decided by the arbitration award. And this court said that they couldn't do that, so.
Thank you.
Thank you.
May it please the court. Kevin Fazell on behalf of Mr. Freeze, the appellee. It might be helpful just to give an overview of the tortured facts of this case, which may answer some of the questions and inform how the arbitrator decided. Mr. Freeze was hired as the president of appellant Greg G. Wright and Sons in 2003. Part of his compensation was that he would be given 3% ownership equity for every year that he served in that capacity. The remaining equity was owned by Mr. Grossman and his mother, Margaret Grossman. Mr. Freeze resigned in March of 2011. At that time, he was a 36% owner of the company. And for the next 2 years after his resignation, he continued to be treated as an owner. Primarily, he was receiving Schedules K-1 indicating his portion of the taxable income or losses. And then suddenly he wasn't. He was the company defied that he was an owner. He quit receiving K-1s, and there was no explanation of where those ownership interests went or why or what happened to him. Among the actions that Mr. Freeze took when he was an employee and owner of GGWS is he guaranteed a number of equipment leases, personally guaranteed, including 3 equipment leases that were ultimately held by PNC Equipment Finance. Those leases went into default, and PNC filed suit in common pleas against GGWS, the company, and Mr. Freeze as a personal guarantor. Mr. Grossman appeared for GGWS. He did not make an appearance for Mr. Freeze. He did not defend Mr. Freeze, nor did the company arrange for anyone to come in and defend Mr. Freeze or tell Mr. Freeze that he could not expect a defense from the company, or in fact that the company was adverse to him. the case lingered on, and ultimately, Tom Grossman's father, David Grossman, formed and funded an LLC, the appellant CKF Ohio Asset Acquisition. Tom Grossman negotiated with PNC on behalf of GGWS and CKF, and they reached a resolution. And the resolution was that CKF would pay PNC $180,000, in return for which claims would be dismissed against GGWS, and they would get to keep the equipment. That's, in my experience, that's pretty typical commercial litigation. I probably have 2 of those in my office right now. But that's not where it ended. The case was not then dismissed. Rather, CKF took an assignment of those leases, substituted themselves in as plaintiff for CKF, took a default judgment against Mr. Freeze, and not for the $180,000 they paid PNC, but for the full claim of $336,000 that PNC was claiming. That's
So
when,
basically, if I'm understanding this correctly, CFK, their agreement with PNC, they acquired the actual equipment and they bought the debt?
that's not my understanding. My
Okay.
understanding was that GGWS kept the equipment and
Yes.
was, and was
That's what I meant.
released.
Okay, yes.
But CKF took an assignment of the paper, of the leases,
Okay.
of the debt.
Okay,
You're right, Your Honor.
yes.
Now, it's, Mr. Grossman's true, that's accurate. There were claims asserted in the state court that were not deemed arbitrable. But the treachery that was inflicted on Mr. Freeze is supported by a number of theories of law, of how you treat a guarantor. There's common law suretyship law, there's uniform commercial code law.
So can we skip to this argument that the indemnification claim was adjudicated in the arbitration without jurisdiction? So it is true that in our first appeal, we held that the right of reimbursement claim was not subject to arbitration. And nonetheless, that claim did wind up in the arbitration. But to me, at least on paper, it looks different. The claim that we held in the first appeal was not arbitrable, was not grounded in the operating agreement, and the claim that the arbitrator adjudicated was grounded in the operating agreement. Can you address whether the arbitrator did in fact have the power to adjudicate that claim?
I can,
And
and I will.
also with that, I don't usually like to jump in, but the counterclaims that were brought in the arbitration, was there a breach of the indemnification clause as a counterclaim? Was that
Right.
included?
It was. It was.
Okay. Mr. Grossman's saying it was not.
It was certainly litigated.
Well, he said it was litigated, but he said it wasn't a counterclaim. So I don't know.
I mean, it certainly dovetails into the breach of fiduciary duty, but to answer your question
Yeah.
first. The operating agreement provides that any dispute regarding the interpretation of this agreement or the rights of the members hereunder shall be settled, finally settled, by binding arbitration conducted expeditiously in accordance with the CPR rules for non-administrative arbitration of business. To indemnification, that's not an unusual provision in an LLC operating agreement, nor is this. Section 4.9 of the operating agreement provides that each person who was or is a member, officer, or agent of the company shall be indemnified by the company to the fullest extent permitted by the law of the state of Ohio against any liability or loss reasonably incurred by such person in such capacity or arising out of acting in such capacity.
So
Good.
that's the origin of the claim that was arbitrated,
That is correct.
that provision. And I understand that you two may read that differently and may have disputes about how the arbitrator should interpret that, but the character of the claim is from the contract.
That is correct, Your Honor. And like I said, you can proceed if Mr. if Mr. Freeze was a stranger to the company, if he wasn't a member or officer or an employee, he would still have rights of indemnification, reimbursement, and a defense under common suretyship law for the UCC. As it is, he was a member and an officer, and so he has these additional rights. And we're in front of an arbitrator. The claimants made claims, the defendants made claims in the arbitration that weren't asserted in state court. We made claims that weren't asserted in state court because we were there in front of this arbitrator for all claims that would arise.
Right, I mean, they asserted a civil conspiracy claim, right?
I know they tried to name me and my partner and a former partner as defendants. I don't know if that was under a conspiracy theory. They also tried to name Mr. Free's elderly parents and his wife as defendants, and I don't recall if that was a civil conspiracy theory. It wasn't granted. I don't recall, as it was a single defendant, so I'm not sure how there would be a conspiracy.
I'm looking at page 4 of the arbitrator's decision, and the arbitrator characterized the breach of the operating agreement as a counterclaim. Whether it was formally raised in the complaint or not, the arbitrator deemed it to be a counterclaim. If that was a mistake, let's assume that Mr. Grossman is correct, and that was a mistake and it was not raised in the counterclaim document. Is that the kind of error that we have the ability to review, given our deferential standard for arbitration awards?
I would submit it's not, because it's a very stiff standard, as the court knows. As this court is held in Colerain Township versus AFSCME Ohio Council, it notes that this court has held that so long as the arbitrator acts within the scope of the contract, they have great latitude in issuing a decision. An arbitrator's improper determination of the facts or misinterpretation of the contract does not provide a basis for reversal of an award by a reviewing court, because it is not enough to show that the arbitrator committed an error, even a serious error. She was clearly, I think, clearly, appropriately adjudicating issues that were squarely raised and empowered by the section of the operating agreement referring the matter to
So an
arbitration.
arbitrator is permitted to rule on a claim that was not submitted? I mean, it sounds like, if Mr. Grossman's correct, this was not one of the counterclaims.
It was, I would
But
say,
yet she ruled on this issue.
it was clearly submitted to the court. It was extensively litigated.
Okay.
And I'm hearing this argument for the first time that, I mean, I've heard this argument many times, that the ruling is inconsistent with this court's holding, referring the matter to arbitration. I'm hearing for the first time that we never asserted the claim for indemnification.
Okay.
As to CKF, there was no adjudication against CKF. There was no judgment entered. It was unavoidable that CKF came up. Mr. Grossman's father formed CKF. He funded CKF. Mr. Grossman negotiated on behalf of CKF. When I was deposing the
CKF didn't file anything below asking the trial court to vacate or not confirm the arbitrator's award. So what are we reviewing with regard to CKF?
I don't know, other than to the extent they have standing to be here with this appeal, only was CKF adversely adjudicated against when they were not named. They weren't a party to the arbitration. We didn't even know who CKF's owners were until I deposed Mary Pat Grossman, who was the accounting officer for Greg G. Wright, and I was asking her about the relationship between GGWS and this and CKF, and I said, "Do you know who the owners are?" And she said, "I am." It's kind of a bombshell, but she said, yes, I am. And when my father-in-law died, he left it to me, and I said, well, is there any documents evidencing that? And she said, not that I know of. I said, well, how do you know you're the owner? And she said, well, I can't tell you because it's attorney-client privilege, how I know. So the fact that all of these Grossmans and GGWS were so intricately involved with CKF, it was unavoidable that CKF was present in the room for those tortured 2 weeks. But that does not mean that she entered a judgment against CKF. There was no judgment entered against CKF.
She just made factual findings.
It was a factual.
You agree they're not binding?
I don't know. I mean, I'm not going to rely on that because I have plenty of deposition testimony to show that CKF and GGWS are one and the same.
I mean, let me ask you the same question. So, I mean, there's these 3 pending claims that you all are going to have to get disposed of at the trial court level. Are you taking the position that you do not need to prove these facts because the arbitrator already found them and that they're binding to CKF?
I'm not taking that position. I've not researched the issue. I'm intending to prove them, and I think I'm already equipped to prove those based upon the testimony.
I mean, if we apply literal collateral estoppel res judicata principles from my perspective, and none of you have briefed this, but from my perspective, that wouldn't apply because CKF was not a party to the arbitration.
I'm not trying to be evasive, but let me just say, Your Honor, I'm not intending to rely upon that conclusion reached by the arbitrator. I'm anticipating that I will have to prove that.
And so the
anew.
trial court, in theory, would be free to reach an opposite factual conclusion if it looked at the evidence that you all create and.
I believe that's correct. I've not researched the issue, but I believe that's correct.
All right.
Your Honors, I'm about out of time. This has been going on more than 11 years. Appellants have brought 7 appeals. There are 2 unsuccessful attempts to dismiss the trial judge, 1 unsuccessful attempt to dismiss the arbitrator, countless delays. It's time for this case to conclude. It's gone the length. The arbitrator wrote a very reasoned, thoughtful opinion. After a 2-week trial and significant post-hearing briefing, this case has been tried, and it's time for it to conclude. So we would ask the court respectfully that you affirm the trial court's decision and judgment entry. Thank you.
You have a total of 3.
Okay,
Okay.
all right, so
So you need 2 minutes and he'll take 1.
paragraph 53 of this court's prior opinion says the following. The claims made by Freeze in his 4th, 5th, and 6th causes of action, that includes reimbursement and indemnity, do not arise from the operating agreement or Freeze status as a member. They arise from his status as personal guarantor on the lease agreements between Greg G. Wright and Sons and CKF Assets Acquisition. Then the court in paragraph 54 dealt specifically with what the arbitrator did. It says, on the other hand, it could be said that Freeze would not have signed the leases as a personal guarantor, but for his status as a member of Greg G. Wright and Sons. But the Fazio test utilized by this court and affirmed by the Ohio Supreme Court is not a but-for test. Express elements, and they go through this claiming, it says in 56, it says, any individual could have signed the lease agreements as guarantor, as Freeze claims to have done. Any individual, having done so, could have then been brought into litigation relating to the lease, which the remainder of the claims arise. And then they found no reimbursement or indemnity claims can be brought.
I'm going to stop you right there. I have the opinion up, and I just did a quick search, and the word indemnity does not appear in this opinion anywhere.
Okay, because the argument that they were making was reimbursement. The claim was for reimbursement, but the court said those are the same things. Indemnity and reimbursement are the same thing. But he couched the original claim as reimbursement because they were trying to avoid arbitration. They realized that indemnity would not be allowed, so they said reimbursement instead. The court said reimbursement and indemnity are the same thing. They are, and elsewhere, courts have said across Ohio that reimbursement and indemnity are the same thing. The court ruled on exactly the basis of this in paragraphs 53, 54, 55, and 56 of the opinion. The arbitrator violated this directly. It did not come up during the arbitration. The arbitration claim was not for indemnity. It was for damages, et cetera. But by the way, there was no indemnifying.
1 minute if you want to leave time.
I'm sorry.
For your
By the way,
colleague.
I am only the lawyer. Mr. Freeze, when the original suit was filed, I didn't defend anybody. I wasn't there. I told Mr. Freeze to handle it. There was 2 suits, the one in 2010 and the one in 2013, 2 suits. The first one was dismissed for lack of prosecution. I'm going to let my colleague make it there.
Your Honor, the key point, I think, to reply is that it could impact CKF, and that gives us standing, a present interest. And the other point is that the Fazio test is the law. You all rejected the but-for test, and the only way the arbitrator brought in the personal PNC lease guarantees was by using the but-for test. It said that he wouldn't have entered those lease guarantees but for being a member of Grey G. Wright, and that's the exact test that this court said is not applicable to arbitrability. Thank you.
All right, thank you. Thank you all for your arguments this morning. The case is now submitted. We'll issue a timely decision. I think you should stay. You're on again. All right. All right, we're going to go over it because it's a little complex. Well, at least for me. Okay, so here's the plan. I think you all were told, just to make sure that we're all on the same page. We have Mr. Grossman, who represents Forrest Gauthier. Is it Gauthier?
It's Gautier.
Gautier.
French, it's French.
Gautier. You get 15 minutes total, and you can reserve time for rebuttal.
This is both of us.
No?
No,
You get for Forrest 15 minutes. And then we have Mr. Fisher for Sue. You also get 15 minutes, and you can reserve rebuttal time as well.
I believe I was told 20.
I'm sorry, you are correct.
Thank you.
20 minutes, and you can reserve, because you have 2 appeals. Mr. Grossman is you have 3 appeals, actually, right? No, 2 appeals.
They are all similar, so. and
Well, you have this, you're in the 60B appeal, and
Yes,
Mr. Grossman is not. Okay. So you get 20 minutes. Mr. Klingler is going to represent himself, 20 minutes total. No rebuttal time. And then we'll go back to Mr. Grossman for his rebuttal time, and then we go back to Mr. Fisher for his rebuttal time. So, Mr. Grossman, how much rebuttal time would you like? 5 minutes. And Mr. Fisher?
10 minutes.
Okay. And I will try to keep all this straight.
Thank you.
All right, so we'll start with Mr. Grossman.
I'd like to respond to Mr. Fizel's arguments.
Okay. Hold on a second. Let me fix your time real quick.
Time flies when you're having so much fun.
Yes. All right, you said you wanted 5 minutes, right?
Thank you.
Okay. Okay, whenever you're
I
ready.
have been before different benches of this court multiple times in the Gautier matter. I've won every single one of them except the last one. However, let me explain why we're here today. These parties, Sue Gautier and Forrest Gautier, with me representing Forrest Gautier, I was with the Taft firm. I represented Forrest for many, many years at Taft. I left Taft in 2011. I continued to represent him only in post-decree action relating to the theft of his property, his personal property, which ultimately Sue Gautier was convicted of the felony of falsification and a theft defense when they found 5 items of his property at her residence, the former marital residence. But I'm not going to go back through all of this, but here's what finally happened. In August of 2024, I provided a settlement agreement to Mr. Bob here today, Klingler. And I said, please tell me whether or not this settlement agreement has been given to Sue. It was a very favorable settlement agreement. Basically, it said that Sue could use and could walk away from most all of the liability that she had. The court in the domestic relations court earlier in that year, at the end of January, had ruled that Sue owed patent costs of $225,000 to Forrest. But then it didn't issue a judgment, and we asked for a judgment in that amount. And one of the reasons why this all came up is in a previous iteration of the multiple appeals that you have had in the Gautier matter was the question of whether or not we could offset the fact of that we owed, that Forrest could be compelled to pay anything to Sue when Sue had not paid for her full patent costs. And there's a provision in the full text
Counsel,
separation.
could I direct your attention to the March 5th hearing? Because we're here on an appeal from the order that was issued from the
Okay,
March 5th
very
hearing.
good. Thank you.
Is it your perspective that the March 5th hearing was evidentiary or non-evidentiary?
The court took evidence, yes.
And what were the mechanisms that it used to do that? Was anybody put under oath? Were any exhibits
I
taken?
don't remember exactly whether Sue Gautier was put under oath, but the court required both Forrest and Sue to be present. And Sue had no lawyer, and I was representing
Were you
Forrest.
able to cross-examine Sue?
No, I was not. I was not allowed to say anything. I was told that I couldn't proffer, that I couldn't make a presentation. I asked to present evidence. I asked to do this because the court was dealing with this question at this point.
And the critical question at that hearing was whether the assignment was authentically signed or not by Sue.
That is
And I
correct.
noticed that you mentioned at one point that you had evidence of other forgeries of her signature. Is that
Yes.
the kind of evidence that you would have
Yes.
put on if you had a
Yes.
chance?
Exactly.
So what, so
That's one of the
I know the
things.
judge told you you couldn't proffer.
The judge, sorry, he
right.
ordered me not to proffer
Correct. Why did you not then just file something in writing about?
because he ordered me not to do that either. He ordered me not to do that. I asked if I could do that. I asked if I could
But
make
you
a
can
proffer
do it, you're
afterwards.
allowed to file, I mean, we've seen this before when judges don't allow people to proffer.
But I would be in contempt. This judge is.
Did he threaten to hold you
you've
in
not-
contempt if you filed
He
anything?
threatened me, he told me I was a liar in court. He threatened me repeatedly. And now, look, I've never been involved with Judge Triggs before, but I obey court orders. So I felt compelled by him because he ordered me not to do this. He threatened me repeatedly. That's why I filed a motion to disqualify him, because his threats against me. He should have been
Well,
disqualified.
one of the things that the judge said in the March 5th order was that he compared the signature on the assignment to 3 other documents that Sue in court said were her signature on those other 3 documents. Did you have a chance to see those documents or to ask
Familiar.
questions about them?
He's wrong. And here's why he's wrong. He doesn't, these are Chinese characters. He is not an expert in Chinese character. And Sue said, no, the one that is the forgery, which is the one on the assignment, she said is not identical to the ones you're talking
So
about.
did
because
you-
he doesn't understand the Chinese
Mr.
characters.
Grossman, the
I'm sorry.
record is a little bit unclear to me. Did you have a chance to inspect those documents and ask?
No, I
questions?
didn't at that time, but I'm familiar with the documents he's talking about because there are previous forgeries. And there was previous forgeries, I believe, by Mr. Klingler. So you have to understand the Chinese characters actually represent something. And sometimes they represent animals. And there's a very specific animal that's represented in the Chinese character for Sue Kang Gautier, and it's not represented accurately. And that's what Sue was telling the judge when she tried to testify about it, and he clamped down on her. I've never seen a proceeding like this, but oh, by the way, this whole bit of the assignment, the judge had no right to deal with the question of whether or not the assignment was validly signed. He had no right to do it. That had to be dealt with in a declaratory judgment action or a separate action in court that was properly litigated, properly noticed, properly with a complaint and answer, proper discovery. None of that was permitted in this thing. This was a court.
And because the assignment was deemed to have been authentic, Forrest's settlement was stricken, right?
Yes.
I mean, he had skin in the game at this
Oh,
proceeding.
big time. And you see, he negotiated and concluded that before we ever knew about the assignment. Now later, because the assignment was filed before it should have been filed, because it wasn't validated, in Florida, in an action in Florida to execute on the judgment. Forrest discovered this on November 6th, after the settlement was all concluded. It wasn't completely memorialized yet, but it was all concluded. And remember, these two parties have been fighting for years. That's why I wouldn't touch her. I said, I'm not being involved with any of this. No affidavit, no signature, no settlement agreement. I'm not involved in this because now they've gotten together. They have finally settled everything. These two parties have been at war for, up to that point, 14 years. Now they settled everything. And Mr. Klingler had, if that assignment was valid, and he did file it in court, but he didn't serve it on me. He didn't serve it on Sue. There's no written notice of this.
Can I ask you about, so there's a fee agreement
Yes.
that Sue signed with Mr. Klingler. And so basically, I thought it said if they get any attorney fees, then he gets the attorney fees.
That's not what it says.
Okay,
It
because
says
I was
something like
questioning
that.
whether,
It is.
sounds like a great settlement with Forrest, but then she still would owe the attorney fees.
Yeah,
to-
sure, she would
to
have owed
Mr.
attorney fees,
Klingler.
but there was multiple attorney fee things. And I think that the contingency of attorney fee, I think is a fraud. But I'm not going to argue with you about that today or with them. I think it's a fraudulent agreement.
But if she settles with Forrest, she still owes attorney fees.
Yeah, because she entered a written agreement with him in 2009 when he started representing her, and she owes on that.
Is that in the record somewhere?
I don't know, but we've done this so many times with you all, and, so I imagine it is someplace, because ultimately I got his file at one point, and it included this agreement, but it did not include.
What is the
contingency.
2009 fee
That was
agreement
the
say?
original retention agreement, and the.
So like an hourly rate or something?
Yep, it was a normal lodestar amount. It was hourly rate. He set forth the hourly rate. He set forth, billing by month. He set for all of that. And you see, that is a binding agreement on her. He entered into another agreement later in another matter up in Warren County where he had another arrangement. This contingency arrangement was strange. One, under Ohio law, ethic rules, it must be in writing. It was not. We raised that with this court. This court in a previous panel said.
Well, wouldn't
Mr.
that go to the validity of the attorney's fees judgment, which is already final?
No, I mean, it's final. I mean, I dispute it. I disputed it over and over again. I won that over and over and over again, and your final opinion basically was I lose. Okay, I disagreed, but okay, I lost. And so we're not contesting that any longer. We disagreed, but we're not contesting it. What we're saying is this: Mr. Klingler, through the summer of 2024 into the fall of 2024, not until November 12th or 13th, didn't raise the assignment. He was pursuing post-judgment execution on behalf of her judgment. And I was saying to him, did you give the settlement agreement to her? I asked her to confirm it. He didn't confirm it. I asked him at a hearing, the first hearing with Triggs at the end of August of 2024, I said to him, did you give her the settlement agreement? He refused to tell me. At a deposition of Forrest on October 3rd of 2024, in the deposition transcript itself, I said, Mr. Klingler, have you given her the settlement agreement? He refused to tell me. He had. He did it at the end of August in this conflict letter. And in the conflict letter, he acknowledges the conflict because he says, well, I've got this, he doesn't mention the assignment. He doesn't mention it at all. He says, but if you accept it, and this may be in your interest, and go get another lawyer, then I can't collect under the judgment. And that's what he told her. And you know what he didn't do? He didn't give her, if he had mentioned that assignment to her when she supposedly signed it that she claims is a forgery, he had to give her informed consent right then and there, and he did not do that. That's why he didn't mention it. He never intended to use this assignment until Sue settled. When she settled and he realized, oh my gosh, she's doing exactly what I told her she had the right to do in that conflict letter, where I was getting informed consent relating to the settlement offer. And he didn't tell me about this. He didn't tell Sue about this. She settles. Forrest compromises his position. They finally resolve everything among themselves. After 14 years of litigation, these parties come together. I and my client does not have to pay them anything because of 7.9B of the full-text separation agreement. The addendum was an amendment to that agreement. It was
Mr.
part of
Grossman,
that agreement.
you are at your initial time
Thank
if you'd
you
like
so
to
much.
reserve. Okay. Let me get this,
Yes.
let's see, you're gonna, 10 minutes.
Yes, Your Honor.
Okay.
Again, may it please the court, Rob Fisher on behalf of Sue Gautier. First day of law school, sitting there in class, professor walking in, we're nervously excited to hear the philosophy coming from the esteemed professors that we have. First words out of his mouth was, a litigant who represents himself as a fool for a client. There's a reason for that, because it doesn't matter how educated, how intelligent, how sophisticated someone is outside of the legal system. If you don't know, or if you're not trained in the legal system, you should have representation. In this case, Sue Gautier was denied that representation. And Your Honor, you hit the nail on the head. There was no evidentiary hearing there. No one was sworn in. No evidence was offered into evidence. Mr. Grossman tried to proffer evidence. There was nothing offered. There was nothing accepted. It was a conversation.
So then how did the trial court make a finding of fact where it compared Sue's signature on the assignment to the 3 documents that she supposedly admitted were her signature if she wasn't placed under oath and those documents weren't taken into evidence?
With no testimony, with no objections, well, there were objections to it, with no opportunity for cross-examination? It's a good question. I don't know how he came about it, because Judge Triggs just ignored due process. A hearing is set for a purpose. It is for testimony to be, sworn testimony to be provided. It is for documents to be provided to be challenged by the attorneys, by the litigants. That did not happen. He completely ignored it. And then he abused the process by disallowing Mr. Grossman and Mr. Gautier to present anything. It was a horrible non-hearing. And there was a very significant decision made out of that horrible non-hearing. There was no process whatsoever. She asked for a 30-day continuance 2 days before that, on March 3rd, in order to obtain counsel to help her with very significant legal issues. You've seen the briefs.
Can I back up just so I understand the timeline, though? I thought there was a hearing that was set for February 12th, and then she moved for a continuance the day before that to get counsel, and then did not show up for that hearing.
Your Honor, she thought she was represented. Mr. Klingler actually had presented himself as her attorney at that time.
So when she filed a motion to continue the February 12th hearing to get new counsel, and she thought she was represented by Mr. Klingler?
Your Honor, Mr. Klingler had presented himself as representing her. She was very confused. We're talking about an elderly individual who, while she has been involved in the court system as a litigant for now 16, 17 years, she's not an attorney. She is not as sophisticated in the legal process.
I'm sympathetic with that, but I'm just trying to understand that, you know, she asked for continuance one day before the February 12th hearing to get counsel, did not show up at the hearing, and then it was continued to March the 5th. And then 3 days or 2 days before that, she again filed a motion to continue that to get counsel, right?
Yes.
Okay.
And that was just a very short period of time. She was just asking for a little bit more time to obtain counsel.
Counsel, it looks like the record reflects, at least Sue's admission at the March 5th hearing, was that Forrest was preparing a lot of these documents for her, and Forrest is her adversary. So how, if at all, does that factor into the continuance analysis? That her adversary is preparing legal filings for her?
They were not adversaries at that time because they had settled their case. The case was not only settled, but it was dismissed in November. Should have been no hearing, should have been no pleadings filed further. How does that play into it? She still was unrepresented, even though she had someone assisting her with, hey, this is what's going on. Here are some documents. Please review these. She should have still had the opportunity to obtain counsel.
But does she just get, how much time does she get to obtain counsel? I mean, my understanding was that at a hearing in November of 2024, Mr. Grossman represented that she had spoken to 2 attorneys that were considering representing her. So then we have the February 12th hearing that she doesn't show up for, that she basically gets that continuance to March the 5th. It sounds like we're just delaying. And so we're looking at abuse of discretion here. How much time does a court allow for a person to get counsel?
When we're dealing with a case that got dismissed in November, she's thinking she's done. Even though there are motions filed, she's still thinking she's done.
Is that on the record?
The fact that it was dismissed,
The
yes.
fact that she didn't understand what was going on and she
No,
thought that they were
because she
finished?
did not have the opportunity to state that at the March 5th hearing. She was never placed on the record to make any sworn statements whatsoever.
Okay, so let me just make sure that I'm understanding the character of the March 5th hearing. So if I'm understanding this correctly, and I'm going to throw several things out here. First of all, nobody was sworn in.
Correct.
Were any documents accepted as exhibits?
Nothing was offered as an exhibit or formally accepted. It was handed to the judge. He looked at it. He made a declaration.
Okay, so did the judge specify which documents he was reviewing for the comparison?
Other than stating that this is the assignment, no.
So-
Nothing marked as an Exhibit 1, Exhibit A, there was nothing.
Okay. And it's also my understanding, and I think you might disagree with this, but when your client appeared at that hearing without counsel, there were two different adversaries there. So at that point,
Correct.
Mr. Klingler was an
Correct.
adversary and Forrest was an adversary.
Technically, correct.
Okay. And, all right, that's all I have for right now.
And not even the adversary had the opportunity to make a statement at that hearing. He was told to sit down,
I understand that.
okay? So that's one issue. Due process was absolutely ignored. The case ought to go back so that we can have due process. That's one alternative. I'm presenting a second alternative, and that is that this court should decide that even if there was, in fact, an assignment in April 4th of 2024, Mr. Klingler waived it, and he assigned it back August of 2024. In that letter that your honors have, it states exactly what her rights are. This is your judgment. You have a judgment of $95,000 and some change. Forrest has potentially a judgment of $225,000. I think it's going to be less, but anyway, he has a judgment against you. There's a supremacy of the judgments. Forrest is first. He collects against you first. You then collect against him. The judgment is for attorney's fees. This is why I'm sending you the letter. This is a conflict. If you agree to the settlement, you are going to be better off. This is in your best interest.
So if she agrees to the settlement with Forrest, does she still then owe Mr. Klingler his attorney fees
His,
through the fee agreement?
no.
She doesn't owe him
And the
anything?
reason, he did it on a contingency. Now, if he wants to go back to the 2009 agreement where he had an hourly rate, he turned it into a contingency in 2022 after this court made a decision that that attorney's fees judgment was not his, it was Sue's. He tried to backdoor that.
I guess maybe I'm reading the fee agreement incorrectly then, because it sounds like if she were to get an attorney fee award, that it would go to him. That's the agreement.
He even states in that conflict letter, if you reach the agreement, I get nothing. His words, not hers. His interpretation of his
I wonder if
contract
he would have
with
a
her.
claim against her then.
He would get nothing.
Okay.
We take risks all the time as attorneys, and this is one of the things I want to bring up on my rebuttal, but I want to talk about attorneys and our risks. But in this case, you can decide, okay, there's an assignment, but it was waived. He waived it in writing. And if he waived it in writing, we didn't even have to go through that 60B process of disavowing it and bringing that back to Sue. He had already done that in August of 2024. This court should decide that this case is
I think
over.
Judge Krause's point is that she received a fee judgment from the court, and that pursuant to her contract with Mr. Klingler, she owed it to him. But instead, she took her fee judgment from the court and made a settlement with Forrest and gave it to Forrest instead. And so potentially, that could give rise to liability to Mr. Klingler in breach of the contract that she has with him. And maybe that's for another day.
That would certainly be for another day. But I can state his words, his interpretation of that contract is in that August 2024 decision. I do not own an assignment.
Well,
That's what he
you're at
said.
your time, so we'll hear from him, and you have 10
Thank
minutes
you.
for rebuttal.
Morning, may it please the court. It's hard to know where to start. We've had 15 years maybe of litigation, rife with, I must say, untruths, and at every turn, ad hominem attacks against me, which we've seen again today, but it is what it is. I appreciate your questions because with so many issues and so much time, I have no idea what you might
I think the due process
need
at the
to
March
know.
5th hearing
And
and
let
the
me s- let-
continuance,
let-
denial, all of that is concerning.
Let me start with that. Well, let me start with this first, Judge, and then I'll get to that immediately. I represented Sue Gautier in this case on a contingent fee basis. It's in the record. It's very clear what it says. It doesn't say what's been represented here. It says my fee will be whatever the court awards in fees, because I knew there was a fee-shifting agreement in the addendum agreement. Loser pays. Sue couldn't pay me. I said, I'll represent you on a contingent fee basis. I won't get any fee. It's very clear. I don't get a fee unless the court awards a fee. The court awarded a fee after years of litigation, $93-some thousand in September of 2022. It's very clear. This is for attorney's fees. It wasn't, I don't get 1/3 of
I
some.
think we understand the lay of the land here. In light of what we're hearing, it does sound, though, like Sue is caught in the crossfires because Forrest apparently does not want to pay you. And that puts Sue in a precarious position because you can no longer represent her interest. You're representing your own. Understandably, you want to be paid. And Forrest does not want to pay you, apparently,
Correct.
because he's going to great lengths to litigate not paying you. And that leaves Sue unprotected, potentially. And she did not have representation below because the court didn't give her a continuance to
Well-
get an attorney. Can you speak to why that was not an abuse of discretion?
Yes, Judge, thank you. As early as November 13th at the hearing with November 13th, 2024, which was weeks after she had apparently been discussing with Forrest his proposed settlement agreement. At that hearing, Mr. Grossman represented to the court that he had been in touch with at least two attorneys who were thinking about representing Sue.
Well, that didn't pan out, apparently,
That
and we
didn't
don't
pan out.
really know why.
Well, it was, what we do know, it was about 4 months before the March 5th hearing. And in the meantime, the judge had ordered Sue and Forrest to be at least 2 separate hearings that they didn't show up for. Forrest had been drafting, and this is clear, Forrest drafts large parts, if not the totality, of these motions that then Sue was signing pro se at the time. But by the time we get to February 12th, there's a February 12th hearing, she asks for a continuance. The judge simply sets, nobody shows up for February 12th. We're already, 2 or 3 months after she's supposedly been talking to attorneys.
Well, the lawyers show up, right?
The lawyers, yes, the lawyers show up.
Not
Thank
the-
you.
not the client.
Did you make an appearance for her at that hearing?
No, Judge, and this is so frustrating. I got a phone call, a voice message in late October, I believe, from Sue, saying, I've been thinking, I've been talking with my brother, this is all in the record, it's in my
Did you ever
affidavit.
file a notice of withdrawal?
I did, Judge, fine.
What date was that?
It was late, and I'll tell you why, because it was clear shortly after that hearing that I wasn't representing her anymore.
Which
She
hearing?
had fired me. The November 13th hearing.
Was she wasn't there, was she?
She was not there, but she.
Okay, and let me ask
forced-
you one more question about that
Yes.
before you move on. When you say that it was represented that she had been in contact with two different attorneys, that wasn't her saying it or her
That
attorney
was
saying
Mr.
it.
Grossman saying it.
Okay, so it's not like she made that representation, somebody else did.
Yes, she wasn't there.
Right.
But the representation was made by Mr. Grossman ostensibly to get some time to let the judge know that I was fired, and now she was looking for new counsel, one of whose jobs was supposedly to prepare litigation against me for something,
Okay.
which has never panned out. But the point is, Judge, at least for November 13th to March 5th, she was apparently looking for counsel. She had called me before and left a cryptic message that I called her back. She didn't return my call. She said, "I want to end representations." At that time, a few days after that, I had an oral argument scheduled in the 12th District Court of Appeals on her case where Forrest was trying to get a $225,000 judgment. I couldn't just stop. And then we had another hearing, the November 13th hearing was scheduled, so I was trying to call her to find out what's going on. That was the status of things on November 13th when I learned for the first time from Mr. Grossman that she's now looking for new counsel, and she's apparently settled the case, and she's taken my attorney fee judgment. She never paid me $1, mind you. She never paid me $1 for fees. I got $93,000, and it's only a fraction of what I spent defending her in that case. So she's not entitled to any of it. But Mr. Grossman announced to the court, now we've settled the case, and we've satisfied the judgment, and we're all done. That was November 13th. March 5th. How long does she need? We've cited cases to your honors, that it's not an abuse of discretion if you give, I don't know, remember, 2 months, 3 months, less than 4 months. There's been several cases in Ohio that say that's enough time. That's enough time.
When did you file the notice of withdrawal?
I don't remember, Judge. I think Judge Triggs, we were at a hearing, it might have been February 12th, I can't swear to it, and Judge Triggs said, yeah, you probably ought to just, I said, I don't know if I need to, Judge. She's filed an affidavit that says I'm fired, so it's pretty clear. He said, well, you probably, I said, okay, I'll file it, and I did. There was no representation by me and no good faith belief by anyone in the courtroom that I was purporting to represent Sue Gauthier after the November 13th. On November 13th, mind you, it was very unclear what the status was. Judge Triggs set a hearing for the next month to quote, get to the bottom of what's going on here, because he was confused. And I was confused. After 15 years of representing her, I suddenly get an affidavit filed under Forrest's credentials with the court.
So if you were confused after your lengthy career in the law, wouldn't an 80-year-old non-native English speaker also be confused?
Judge, let me answer it this way. All I know is this. She had decided, apparently, that she was going to fire me and make peace with Forrest. And one of the deals was, of course, that she would take whatever power she had in the attorney fee judgment and get rid of it. The whole point of the settlement was to deprive me of attorney's fees. So she was doing that with Forrest. She had a brother who I've never met, who I asked, let's meet with your brother after I got this cryptic phone call, because she relies on him. And he apparently helped negotiate an agreement with Forrest. So Mr. Grossman, understandably, was trying to step away from it, I guess, because he saw the conflict that he was in. So he wasn't filing anything on behalf of Sue. Forrest was filing things on behalf of Sue. So was she confused? I don't know. I let her know with an email that the judge wanted her to be at the December, whatever it was, hearing. And I have to believe that she was that Mr. Grossman wasn't making misrepresentations to the court on November 13th when he said she's got two attorneys that are looking at the case. I don't know, maybe he was misrepresenting. Nobody had any reason to think that. It's November 13th, she's looking for counsel. Okay, let's set it. Okay, let's set it again. Okay, move to continue. Let's set it again for March 5th. How, you know.
So, you know, that's, I mean, an issue, but let's just say for sake of argument that the judge did not abuse his discretion in not giving her a continuance. What about all of the other arguments about the due process violations that occurred at this hearing?
Our position is this, Judge. As a trier of, Judge Triggs was making factual findings at that hearing.
How do you do that when you don't have anyone under oath and nothing filed as an exhibit?
Well, first of all, there were exhibits that were shown. I had a whole binder of exhibits I was ready to use at that hearing. We were standing at the podium. Sue was here. Forrest walked up with her. Now they're together. They were there, and Mr. Grossman was there, and the judge asked her if that's her signature, showed her the assignment. She seemed a little confused. And then there was some intervention. Forrest was trying to coach her, and the judge said, stop. You know, Forrest was trying to tell her, yes, that's. So finally the judge said, is that your signature on that assignment?
And she's not under oath at this point?
No, she's not under oath, but she's not under oath, but she didn't say anything against her interest. She said, no, that's not my signature. And then I showed her some exhibits that I have. They're all in the record. Mr. Grossman has all of them. 2 or 3 signed documents.
They weren't marked as exhibits
They
in
weren't-
the
they weren't-
traditional way.
They weren't entered into evidence, Judge, but the record does show.
So then how do we review the trial court's factual finding?
They are in the record, actually.
Well, I've looked. I've looked for them, and I can't find them. So
Well,
where would they be?
They would be, they would be in we filed a response to a motion to continue this hearing to allow discovery.
So then how do we know, though?
We attached a lengthy PDF of all the exhibits that I had marked for that hearing, and so it is in the record.
So the documents that the trial court used to compare the signatures?
Yes, are in those exhibits,
Are in
because I
those
had them in my
exhibits.
binder, and when the motion was made,
How do we know, though? And I mean, I believe you. I'm not questioning your
Yeah,
veracity
understood.
right now. But how do we know that those exhibits from that other document were the ones that the trial court reviewed? I mean,
because I
that's
read
the
it into the
purpose-
record, because I read it into.
But that's the purpose of taking an exhibit into evidence, so that we can then review the actual document. Things happen, people look at things differently, copies are made differently. We
Well-
don't actually know that that's what the trial court reviewed unless
You-
it's
you-
marked as an
you-
exhibit.
Well, I understand what you're saying, Judge, but my point is you will know, because I say on the record, and it's in the transcript, Your Honor, I'm showing her an affidavit dated such and such and such and such, notarized by me in 2016 or whatever, and so it's clear, and if you go to the exhibits we filed, you will be able to see it for what it's worth. It's got her Chinese signature on it. They all look a
And
little
so
different.
I've looked at different iterations of her signature, and to me, they do look different over periods of time.
Like everybody's does. All I can say, Judge, is the court made a factual finding. Expert witnesses, we've cited cases, are not required. A finder of fact, a jury can look at documents and decide whether or not a signature is authentic, and that's what Judge Triggs did. And he was right. And I want to make this point.
And so to you, it's not material that she was not under oath when she agreed that the notarized signatures were hers?
No.
Because that's critical, right? I mean, you
don't-
need her to say those, I
There's-
signed those documents.
There's no contention by anyone that I'm aware of that she was wrong or gave testimony that wasn't true because she wasn't under oath.
Well, was it testimony?
Well,
I mean, in a jury instruction, we're constantly saying, the statements of lawyers are not evidence. And if she's there representing herself and she's not under oath, she's really just speaking as a lawyer. She's just giving argument. That's not testimony.
well, I agree that it's not testimony. My contention is, though, and we cited some law in one of our briefs, that as the finder of fact in that hearing, Judge Triggs was within his discretion to question her, whether under oath or not. I don't know that that really matters in this case, and because she said, that's not my signature. Now, and then there were documents from years ago. It's proved in my affidavits and in the other filings. She signed these documents over many, many years. And she admitted, yes, that's my signature. There's no reason to think, except from what Mr. Grossman just said today, that he believes there's other forgeries. She's never said that.
What about Forrest's position that he wasn't able to offer evidence or cross-examine Sue? I mean, he did suggest on the record that he had evidence of other forgeries. I don't know if that's true or not true, but he was
certainly not
stopped
true.
from offering that evidence.
Judge Triggs had, and could properly take into account, a lengthy affidavit from me that I assume you've read, and it was filed, I think, December 17th, and the document that I referred to earlier, the PDF with all the exhibits that was filed, has all of the backup emails and everything that support my affidavit, that made it very, very clear that over years I went to her on April 7th of 2024 and got her signature. The texts are there in evidence.
So you're arguing.
Overwhelming evidence that this was not a forged signature.
But you don't believe there needed to be evidence or testimony taken, right? Isn't your argument that the judge could decide all of this on the affidavits?
Yes, I think.
Well, there wasn't any testimony taken.
I think that's true. He could make these decisions based on the affidavits.
So no evidentiary hearing,
Was
according to you,
required.
is required?
Was required.
Okay.
She throws up.
Even if the parties ask for one, the judge is in his discretion to say, no, I'm deciding this on the
Yes,
file.
exactly. Thank you, Judge. That's exactly right. Because the affidavits, in my view, are very clear and overwhelming. And to say that a judge has to now go through let's have a hearing so you can come, when there's nothing there.
Well, okay, let me try to understand this, and I understand what the rule says. But my question, if there are facts that are disputed, and it depends upon the credibility of the people involved, how is a trial court to make a credibility determination based on affidavits rather than on in-person testimony?
I think a court can do that based on the common sense, the convincingness, the reasonableness of the filings. Her affidavit, the whole reason we're here was she wrote that affidavit that had lie after lie after lie. My affidavit in response refuted every single one of them.
So
They haven't disputed.
Therefore, it is disputed
Well-
what she said versus what you said.
Exactly.
Right.
It's definitely disputed, Judge, but I don't think that means you need live testimony to make a decision when it's so clear that what she posited is just garbage that Forrest put in my affidavit. just goes,
How is that clear? How is it clear that what she posited is garbage?
because my affidavit refers to documents and facts that are that are irrefutable. She said, for example, that I never paid her share of some money that came in 2010. My affidavit goes through details of why that's not true and why she did receive her money, and the exhibits that we filed back that up. So there's documentary proof in the record that everything in that affidavit was false.
Even if we agree with you, though, the trial court's order, which I understand from the record you prepared, says that the court, as the finder of fact, compared the signature on the assignment with these 3 other comparator documents. And that occurred at the March 5th hearing. That didn't occur in these affidavits. In fact, this proposed order doesn't really speak to the affidavits. So it looks as though the order resolves the dispute of fact based on what happened at the March 5th hearing.
I would simply say, Judge, that the order does also say that the judge has reviewed all of the documents. So he didn't enter that hearing in a vacuum. He understood the background of what was going on, and he frankly had lost some patience with what we've been going through here. But I will certainly admit that it would have been preferred if evidence had been taken and witnesses had been put under oath.
And you could have testified too,
I
right?
could have. I was prepared to. As I said, I had an exhibit book. I was ready to go. I was disappointed that we didn't have a full-blown evidentiary hearing because I was ready to do that. If that is something that this court thinks needs to have happened, then I would simply suggest, to the extent possible, the issues be narrowed, because what's going to happen if we go back down is that it's going to all blow up again if there's any leeway in, oh, well, let's look at whether, whatever. So that would be my suggestion and request, as apparently was the case in the prior argument. This case has gone on for way too long, many, many years. We're here because I did some pretty darn good, if I may say so myself, attorney work on behalf of Sue Gauthier on a contingent fee basis that I've never been paid for. And the only reason we're here is because Forrest convinced her somehow with a settlement agreement that's in the record that you've seen that also says that he'll pursue me for whatever on her behalf, and they'll split 50-50 whatever they recover. So it's just game after game, delay after delay. It's the same kind of thing that it sounds like was going on before, and it's just time to put an end to it. I'd like to get my fees at some point, but it's gone way beyond the fees, frankly. I mean, my reputation has been, I'm sitting up here for 15 plus 20 minutes in a row listening, and I got some more coming.
You actually are at your time.
At my time. So
You do have some more coming.
thank you very much for your attention.
Thank you. All right, Mr. Grossman, you have 5 minutes in rebuttal.
First off, his contingency agreement has 2 conditions precedent. One is that Sue prevails as a prevailing party. 2, that she actually collects the fees. Those are the 2 conditions. She first had to prevail, which unfortunately she did, and 2, she must collect. Now, what he doesn't tell you is that she obviously had the right to determine whether to collect or not. It was her decision to collect. Now, he wants to interpret collection, I don't know, some other way, but remember, he's the drafter of this agreement. It's interpreted against him. Sue had every right to believe that she could determine whether to collect, and that foots with his attempt at this conflict letter, where he's saying, it's in your interest to entertain that settlement agreement and to not collect from Forrest, and then I can't collect from you. Now, what about his fees? He's collected tens and tens and tens of thousands of dollars in fees. It is not true that, and he's had an original fee agreement, he's had another fee agreement, and then he did this funny contingency agreement, which we never knew about until way later in an appeal in this court. And there's a reason why he invented this, and this is an invention. Because he wanted to raise his hourly rate, not based upon the hourly rate that he was charging at the time that he actually did the work. He wanted to do it at the end of the case. So when he lost multiple times in this court, and the court decided that he could not collect fees on the entire case, but could only collect fees with regard to the matters he prevailed in, then he tried to raise his hourly rate, not based upon what he could, and this is what was really happening. He did this. He invented the contingency matter to raise the hourly rate to $500 an hour. So when he lost the argument that he was originally given by Judge Foley, which said the entire case was frivolous, and therefore he could collect all of his fees, and then he lost that in one of our appeals because it was not frivolous. Judge Myers ruled that it was not frivolous at all because, in fact, there was jurisdiction in this court for us to bring the original action, and the court so found that there was evidence of that. And it was not frivolous on my part. When he lost that, then he tried to raise his rate. And I mentioned this to him in Warren County in a proceeding. It's before he alleged this contingency fee matter. And I said, why are you raising your rate? You can't raise your rate. You got to charge the rate that existed at the time that the fees were actually billable by you, which was every month. That's where he came up with the contingency fee idea. And he didn't put it in writing. And we said, wait a second. If it's a contingency, you've got to have it in writing. And it wasn't in writing. So it wasn't until 2022, February, when we had the last oral argument, that the court asked him, a previous panel, said, where's your in writing on this? He said, well, you're right. I didn't have one, but I've done one now. Okay. So here's the deal. Now, whatever the position that Mr. Fisher takes on behalf of her, he had a right to charge for his fees under the original agreement. He had a right to collect fees. He has a right to collect fees, in my opinion, right now under a quantum error theory, even if you don't have an agreement, even if he lost. However, if this contingency fee agreement is drafted by him, and it was drafted by him, and it was really specific how he drafted it. It was really interesting because he drafted it with knowledge of his winning already. He didn't draft with, there was no reason for him to do a contingency fee arrangement, none whatsoever, because you know what he could do? If she didn't win, not charge her. That's all he had to do. He could say, you know, Sue, he didn't have to enter this agreement. The only reason he did it was to create an increase in his hourly time. That's why he did it. He could have sat there with Sue and said, you know what, Sue, I'm going to charge you on my normal billing rate, on my normal lodestar analysis. I'm going to do that. But if you lose, I can decide not to bill you at all. Exactly. That's what he could do. Why would he take a case where he knew we were right? And the stuff that he prevailed on, I mean, it's piddly nothing. He prevailed on a matter involving $3,000, which relates to her not reporting the $150,000 that she made that she was supposed to report on her taxes for 2010. And we won on that. The only reason why we didn't prevail, we were the prevailing party on it, but there's a strange rule in Ohio, I think it's wrong, but it is that in order to be a prevailing party, you've got to get a judgment. We won on that argument because they changed their position and they filed a new tax return in September 2013, and then we won that first case. We lost only this. We only lost the fact that we also asked for the accounting fees, $3,000. That's what we lost on. But we won on the main point we were making, why we brought the case, which was you've got to report the $150,000 that you received in the in the addendum agreement, and you didn't report it, and then we got audited by the IRS, and when we got audited by the IRS, we told them, Mr. Klingler, I called him up and said, we're being audited by the IRS because she didn't report her income, and Forrest has taken a deduction, as he's allowed to do, for alimony payments, and that 150 was an alimony payment. They contested this because they were hoping that the IRS would decide that it wasn't alimony. Now, the IRS didn't dispute that at all. Once the IRS knew, once they knew that Sue had actually received the 150, and then they've gotten proof of that, then she had to file an amended return in September 2013, and we won that part of the case. The only reason why we weren't the prevailing party is because you have to have a judgment. But we didn't need a judgment.
You are at
I'm
your
out of
time
my
on
time.
rebuttal, yeah.
I'm always excited.
You were on
to
a
be in
roll,
front of
though.
you. I know I am. And by the way, can I make one more statement? Because this is really important. The Sue discharged him before the November hearing, but the judge did not accept that. He said, nope, he's still her attorney.
Mr. Fisher can
Yeah,
address that.
I'll let
Thank
him
you.
do that.
Thank you, on behalf of his client. Mr. Fisher, you have 10 minutes.
Almost ready to defer sometimes, Mr.
You got your 10 minutes.
Thank you. With regard to the due process argument with Judge Triggs in that March 5th, even he understood that he was about to cross a line or did cross a line, because he said, Sue, if you go and get an attorney now, come back, I'll reverse this judgment, and we'll go have a full hearing. That's on the record.
So the entry that he entered, I think it was the same day, I can't remember, was that a final entry, or was that a final order?
Yes.
Was there anything left?
No, not with regard to the issue of the assignment.
Okay,
But he said, if you go hire an attorney, here's what I'm going to order. But I will technically grant you that continuance. You go get an attorney, come back, we will dismiss this order, vacate it, and then we'll go have a hearing. She hired an attorney, me. We entered our appearance,
how much later was that? Was that like a month?
April, yes,
Okay.
April 9th, I believe.
She
So
filed,
approximately
when
a
was the
month.
notice of appeal was filed before you came on?
Before I technically entered my appearance on that case, correct, we did file the
So
notice.
she filed a notice of appeal with us,
Correct.
and then you came in, entered your appearance, and filed the 60B.
Correct. No, but point is, Judge Triggs knew he had crossed the line. That due process was not granted to anybody. Even Mr. Klingler didn't have due process granted to him. And you brought up the fact that there were no documents entered, and if he had a binder full of documents, he could have entered that, we might not be here.
Can I ask you, though, is the judge permitted, would the judge have been permitted, if he hadn't questioned Sue? I mean, I know you have an issue with the continuance, but if he hadn't questioned Sue and he simply relied on what was filed, could he have done that to decide this case?
To test credibility of paper would be very hard to do. So I would present to you no, that he would.
So there would, under no circumstances,
The
could,
only
because
thing-
the rule says he may have an evidentiary hearing, or he may rule on the papers.
When there are such issues of credibility. Motions get filed all the time, Your Honor, and we have legal issues all the time with motions. When a motion gets filed and there's a legal issue to be decided, yes, we don't need a hearing. But if there's a factual issue to be determined where the parties, Mr. Klingler coming in with a binder full of documents to present,
So he
Yes,
could never
you
rely
need to-
on affidavits.
you can rely on an affidavit. However, even in trials, you can't rely on the affidavit for a jury.
Sure.
Okay, so we require people to show up for a trial for a reason. We require people to attend the motion hearings for a reason, and that is to gather that testimony, live testimony, under oath. Tell me what is truth. I will determine the facts as judge, but you tell me what the truth is. Without that, no, you can't have a legitimate hearing. Due process was denied. But again, I want to bring up the fact that we have an assignment, allegedly signed by Sue, early April, 4th, 7th, whatever the date was, okay? That assignment can be withdrawn. That assignment was withdrawn not once by Sue, but twice by Sue. Once in November of 2024 and again last year. She withdrew the assignment. even if she could not, on her own, unilaterally withdraw that assignment, Mr. Klingler gave it up. You have that letter? That letter in August, 4.5 months, almost 5 full months after the assignment was entered into the record with no notice to anybody, he told Sue, this is your judgment. This is your right to get rid of this judgment. You have a judgment against you that is supreme, $225,000. You must pay that full $225,000 before you can collect this $95,000. Your judgment. This court even had an order that this is not his judgment.
Do you have any case, I understand you to be making a waiver argument, that you're saying that his statement in the conflict letter waived his interest in the assignment. Do you have any case law to support something like that?
Your Honor, it's factual. It's not just case law. The case law is he can give it up.
Let me give you a
That's what the case law
hypothetical.
is.
Let me give you a hypothetical. Let's say that I sign a lease with a landlord to rent a space, and we've got a lease and I paid my rent, and then I go out and tell somebody, I don't rent there. Have I waived my leasehold?
Completely different.
How?
No, you did not. The assignment is this, okay? I have a judgment. Sue has a judgment. This court determined it's not his judgment, it's her judgment. He keeps mistaking this as his. Yeah, he wants to get paid. I get it. Okay? I would love for him to be paid. However, there's a judgment that Sue owns. She gave it to him. No consideration whatsoever was given to Sue for this, right? Which is different than your lease, because there's consideration. There's money going one way, there's a leasehold, there's property ownership.
Well, isn't that
going
a
another
different
way.
argument? I mean, the argument you're making now is that the assignment was never valid in the first place.
I'm making two different arguments. I'm saying that yes, the assignment was not valid. However, even if you accept it as valid, he gave it up. And he had the right to do that. He could give it right back to Sue. And in that August 2024 letter, he acknowledged it was not his. 4.5 months after he says, you assigned it to me, he says, no, this is not my judgment. This is yours. You have the right to settle with force. Again, there's the supremacy of judgments. She is, because of his actions, trying to collect this $93,000 with interest, over $95,000 now. She is now subjected to owing Mr. Gauthier $225,000 plus interest. He is completely going against her interests to protect his own. That should not be allowed.
Well, he's withdrawn from representing her, so what's wrong with him representing his own interest in collecting a judgment that he thinks that he has?
But it's not against Mr. Gauthier. He doesn't own that.
Well, he claims that he does. I understand you see this differently, but he believes that he is the owner of the judgment. So what is wrong with him collecting a judgment that he believes he owns?
Because he doesn't own it. I can believe I own the White House. I don't own the White House. Maybe as a
Well,
taxpayer.
isn't that your actual dispute?
That needs to be decided by a court. With evidence, with testimony, with due process that is guaranteed to
Well,
the
it was decided by
parties.
a court, but you said it was.
Without
not due
the
process.
evidence, without the due process.
May I speak to the?
No. This is
All
his
right.
time.
But he gave it up. He gave it right back to her. And when he gave it right back to her, he said, you have the right to settle. And she did. What she did was she terminated, he brings up, this is not the first case you heard today that's been going on forever, needs to end. Absolutely right, it does need to end. The only way this is going to end is the way the parties, Sue and Forrest, actually ended it. They decided, Sue, you do not owe me $225,000. I do not owe you that $95,000.
How does that conclusively end the situation? Because it sounds like Mr. Klingler would then have a breach of contract claim against Sue, and that could resolve however it resolves, but there would still be a remaining claim between those two parties.
Yes, there could.
So this doesn't end the way that you say that it does.
It ends it between Sue and Forrest. They are the ones that have been litigating forever. They found a way to stop their litigation. Yeah. Is there going to be something between Mr. Klingler, if you rule the way we ask you to do? Could he file an action against it? Yeah, he could. Okay? Absolutely he could. But right now, he, by pursuing this, is subjecting her to a $225,000 judgment plus interest. She would only owe him, what, the $93,000 plus interest. She will take that. That is much more to her benefit. He knows it. He wrote it in that August letter. This case is about resolving the matter between Forrest and Sue, the way they asked, the way they decided, the way they had the right to do so, and he acknowledged it, and that is to settle the case, resolve it, dismiss the actions, go forward. They can live their lives peacefully between the two of them, and that matters more to them than anything. Thank you. I appreciate your time.
Thank you. Thank you all for your arguments today on this very complex case. It is now submitted, and we will issue a timely decision. Have a good rest of your day.